industry's a recent innovation. Music's been alive, thriving since cavemen. Folk songs so long I've had a place in communities that you should be amazed at it. Then one day came intellectual property, meaning if I think a thought you can't copy me. And if honesty's the best policy, I'd say songs are better off without this monopoly. It'd blatantly be a major fail if they patented the major scale. And downloads don't equate to sales, so taking them away won't make you pay up. Just precludes me from sending your tunes to my friends, so we all lose.
Hello, and welcome to the Tech Dirt Podcast. I'm Mike Masnick. A few weeks back, we did a two-parter on patents, and with a bunch of people suggesting a companion piece on copyrights, that's what we're going to try and do this week and next week as well. If you're a Tech Dirt regular, you know that copyright is a topic of great interest on the site for a variety of reasons, and perhaps the biggest of all is that we've seen how frequently copyright law has been abused in order to stifle speech and innovation, and that personally worries me quite a bit. But one thing that always comes up whenever we dive into these discussions is how widely misunderstood most people are about copyright, what it's for, and what it actually does. In just the last month or so, we've had some crazy stories on Tech Dirt about an attempt to demand licensing fees from news organizations over a video of a police officer in South Carolina shooting an unarmed man. A woman in California claiming that anyone making a periodic table of HTML5 elements has to credit her very different version, or have their versions taken down, and some comic artists claiming that the fact that Iron Man wears a full body armor suit infringes on their copyright of a different character wearing a full body armor suit. All of these stories are obviously ridiculous to those with any experience in copyright law, but what's somewhat shocking is that we've seen some people step up and try and defend all of them, always using some faulty understandings of what copyright is really about. Our podcast co-host, Hirsch Reddy, after getting engaged in an argument with someone about one of these stories on Facebook, suggested that we need to do a Copyright 101 podcast explaining copyright's basics. But I thought it might be more fun to focus on common misconceptions around copyright. And to do so, bring in a special guest. So today, along with our usual co-hosts of Hirsch Reddy and Dennis Yang, we have Parker Higgins, an activist at the Electronic Frontier Foundation and a regular commenter on copyright issues. So to kick it off, let's talk about some common misconceptions that there are with copyright law. And I'll start it off with my favorite, and that's the idea that, well, someone must own it. And from there, I'll toss it over to our guest of honor, Parker, to lead off with a personal favorite misconception, if you have one.
Let's see. I was all ready to get fired up about the monkey selfie and someone must own it.
You can do that.
I like, so I'm a big fan of fair use, and I have always thought it's funny how I think the test for fair use, it's you have to apply something, but it's not that hard to understand how the four factors work. But people so desperately want there to be bright line tests. Yeah. And so it will be no. If it's under 3 notes, or if it's 30
less than 20 seconds.
Yeah.
Right.
And sometimes you go no. I mean, you can look. It's not just common law anymore. It's statutory. We've got these 4 factors, and they go no. But if it's in a commercial, it can't be fair use.
Right. Yeah. And I think that's a good one. The fact that many people assume that if there's any commercial element to it whatsoever, that there can't be fair use, and that's
so just to clarify, like what are those the 4 factors? If I'm not exactly familiar with.
Well, so they're laid out in the statute. It's Section 107, and it's without doing like the full on master class, but purpose and character of the use.
Right.
I have to make sure I've got these in the right order.
The order doesn't matter.
Amount and substantiality of the portion used, nature of the copyrighted work, and potential effect on the market. And so these are, it's 4 things to keep in your head, and I don't expect everyone to be able to do this, but knowing that there's a test we apply, is different from saying
and also just to be clear, because this is another thing that people do get confused about, right? Is the law is that judges have to apply those 4 things and look at them, but that's not all. They can apply other tests, and they can basically make up their own tests on top of that. And also, it's not a pure, if you get 3 out of the 4, you have fair use. You can weight the different factors differently, and in fact, judges will often do that.
Yeah, there are cases where you've got one factor in favor of fair use, and they go, yeah, but it's one really important factor.
So I feel like we've already gone off into the deep end of the pool with this very nuanced technical stuff about copyright. I want to bring it back a few steps.
Sure.
I think let me just talk a little bit about like what is copyright versus things like trademark or even patents for things.
Okay.
For example, right?
So,
did you want to say something about that?
Well, I was just going to, so let's go back to the very basics, which is the Constitution, right? So copyright and patents come from the Constitution, trademarks don't. Right. So copyrights and patents are, what is it? Section 8?
Article 1, Section
Article
8,
1,
Clause
Section
8.
8. Yes, Clause 8. There's 2 8s in there.
188.
Yeah. And it is to promote the progress of science and the useful arts. I forget something about, grant to artists and...
I think people get the gist
right.
of it.
But it's to promote...
It's to encourage people to do things,
Right.
useful, creative things. Yeah.
Right. And technically, if you go back to the Constitution and you want to go really back to sort of first principles, and people get this mixed up because it's science and the useful arts, right? And people assume that copyright is for useful arts and patents is for science, and they actually have it backwards. Originally, the useful arts part was really for patents, and that was for inventions and technologies, and science was what copyright was about. And science at that time meaning basically the same thing as education or learning. So technically speaking, if we go all the way back and just look at the Constitution, you would say copyright is supposed to be to encourage education and learning. We've gotten very, very far from that, right?
Yeah. And it's useful to also talk about trademark. Trademark originated from sort of common law ways of protecting the source or marks on goods, so people would know which
Right.
merchant a particular banana came from, or a wheel of cheese, for
Right.
example.
And I always like to say, and some people disagree with this, but I like to say that the difference with trademark law is trademark law, even though everyone likes to lump the 3 of those together, trademark law is really a consumer protection kind of statute,
Exactly.
right? So it's, you don't buy something thinking that it's Coca-Cola when it's really Hershey's Cola, and you put, something bad in it.
The other way around, Hershey's Cola is friggin' delicious.
Or that. And yet, over time, it's sort of been morphed into this idea that basically because of the phrase intellectual property and sort of the mindset that brings up. And I think that brings us back to the idea of this podcast itself, which is the misconceptions around copyright. And a lot of it has to do with just this idea that it's property as in the same thing as physical or tangible property.
Well, okay, so let's talk about copyright and patent and trademark, though, just in terms of like just what they're supposed to be, right? Like
Sure,
very
okay.
briefly. Okay, what is copyright? You get a copyright, when you put something down on paper, when you paint a picture, when you do, anything, you make a sculpture.
Anything that you can fix.
Anything that you put in, it's literally written in the law, into a tangible medium. That is something that's created. You don't have to go to someone. You don't have to register it, anything like that. And it's supposed to protect your creative expression.
Right.
That's what it is. Now, what is it?
For a limited time.
For a limited time. That's a key part. What is a patent? A patent is a little different. A patent is also for sort of a creative expression in a sense, but it's for an invention. It's for a technique of doing something. It's for a specific design. It's for, for example, a method of making a particular chemical, let's say. You can also get a patent for a mechanical device, right? And I think that's the classic one that everyone's always thinking about.
Right.
And nowadays...
And to do that, you have to apply and go through an application
Exactly.
process.
So you don't automatically get it, right? You got to apply. You go to the U.S. Patent Office, and they look at it. And that's also for a limited period of time. And the reason there's this heightened burden for patents is because patents are a little bit more powerful than copyrights.
Sure.
In copyright, what is the key thing that it limits people from doing? The key thing is, I would say at the most basic level, copyright prevents other people from copying verbatim what you've done, for the most part.
Reproducing the
what you've done,
technical-
right? Whereas patent, and also, by the way, there actually has to, in copyright, we have to, when you're bringing a copyright lawsuit, you actually have to show that the person who copied something had access to your stuff and actually copied it. So if there's just similarity without
Right.
access, so for example, let me give you a classic example. If someone was born in a bank vault and never left it, and there's proof that he was in this bank vault, and he produces a verbatim copy of Michael Jackson's Thriller. Now, it's a crazy coincidence, but we
Right.
can prove that he was in the vault and just somehow
Right. That's not copyright
That's
infringement.
not copyright infringement. It is note by note exactly the same. It doesn't matter. It's not copyright infringement. And that's the thing people fail to understand. I think, a lot.
Even courts at times
Fail to understand that, right? Well, the reason I think the courts is a little bit more nuanced, because of similarity in the real world, because we can't prove that someone lived in a vault, if things are so identical, courts say that that's probably an indication that it was a copy. So, for example, if I produce tomorrow Thriller verbatim with the same
Right.
arrangements, everyone in this table is going to be like, Hirsch copying Michael Jackson. He's not good at music, and it's just too much of a coincidence.
He's good at cola, but he's not a music guy.
Right. Whereas on patent, you don't have to prove
Right.
that I don't have. Mike doesn't have to prove that I copied
Right,
his
that
very
doesn't
specific way of making a chemical.
Which is-
he just has to show that that there's this threshold similarity between the methods.
Right.
And that's the thing that people don't understand, and that's also the reason why there's a whole examination process with patents. And so that's a very sort of key thing. And then finally, with trademarks, let's just touch on trademarks very briefly. A trademark, even though people look and they say, okay, I'm going to make this really crazy name for a character.
Right.
Let's call him Mickey Mouse, right? And I'm going to sell T-shirts with the Mickey Mouse name on it, right? And now it's true. If you were the first one to create Mickey Mouse and you started putting Mickey Mouse brand cookies, Mickey Mouse brand T-shirts, all these things, it is true that the courts will protect your right to use Mickey Mouse in those narrow band of things that you have started selling.
Mm-hmm.
But that word Mickey Mouse, you can't stop someone from making a story about Mickey Mouse that says, I got a Mickey Mouse the character. In the trademark case, you got to. If you didn't make stories about Mickey Mouse, and they can't stop you,
Right.
Because Mickey Mouse here is to. So let me give you a better example of that. I can make a character named Boeing.
Uh-huh.
All right, and he's Boeing the Boeing the Badger.
Okay.
Boeing the Badger. Boeing the jet company can't stop me from making Boeing the Badger. I can make Boeing the Badger
Right.
whatever I want. Now the thing I can't do is make Boeing the Badger jets and
Right.
sell them, because that would cause confusion. Confusion is the key thing here.
Right. And I mean, we're going to go
Yeah.
way deep into rabbit
Right.
holes and tangents. I mean, there are issues of dilution and,
Yeah,
and
yeah,
all
a
sorts of
lot
other
to
stuff.
it.
But yes, conceptually, that is.
So that's the key thing you should ask when someone says, hey, so the next time you come up with a cool character name or something like that, and someone says, hey, Mike, you should trademark that. You should be like, no, because I don't plan to sell Boeing the Badger.
And that's actually a really important point too that you didn't mention, which is that trademark only applies for use in commerce.
Exactly.
Right. And so, and the fact that these three things, people confuse them all the time. And in fact, a lot of news articles will call copyrights patents or trademarks, and they'll go interchangeably back and forth between them and not recognize the differences. And I think that certainly leads to a lot of the confusion and misunderstanding. And people assume that things that are true for patents or trademarks have to also apply for copyright and things like that.
Exactly. And this is one of the reasons also when people when advocates get together and say, hey, copyright has gone too far or patents have gone too far, and they explain something where it's like, okay, this let's say patent troll has been going around and trolling, say, podcasters. Well, people think, well, there must be a control on that as long as the podcasters can prove that they were podcasting from before this guy, or didn't even know about this guy's podcasting patent, and that means that they're probably safe. That's not true.
Right.
We could be podcasting and never copied anything from that guy's podcasting patent, and we're still liable. And people don't realize, think about how unfair that is. We're sitting here,
Right.
we just hooked up some mics, and we start recording, and we think, hey,
Shh, don't tell anyone.
Yeah,
You're going to get a suit.
No, but you see what I'm saying? Like, you could get sued by the podcasting patent.
Not anymore.
Well, that one's been invalidated.
Thanks to EFF.
Yeah. Thanks, Parker. But you see what I mean? And people just don't realize that kind of thing. And I think if they did a little bit more, they would
Yeah,
understand.
and that's in the patent context, and we already did 2 podcasts.
Yeah,
on this.
yeah.
Let's get back to copyright.
Right.
So let's talk about. I mean, in general, beyond just we went deep on sort of the fair use thing, but what else do you see as sort of common misconceptions around copyright, or what things sort of pet peeves that you have personally about it?
So another big one is the copyright. I mean, obviously, copyright is a law. It's like it's from the government enforces things, and we set aside court time, and so when we come up with questions like fairness or plagiarism or attribution or like, well, you should have given me credit, that is not covered by the law and probably shouldn't. Like we don't really need. I think that there are really good questions of fairness. Yeah, and that you should absolutely call out someone who's doing something unfair. Or
right, but these are and this is an important point, and it actually came up in that thing with the HTML5 periodic table of the elements, which was she kept going on about credit, and this is one thing that most people really who don't spend any time with copyright get wrong, and they think that credit is a part of it, and they think that plagiarism and copyright infringement are the same things when they're not.
Totally different.
I mean,
they can overlap.
They can overlap,
but then they can also
not.
They can not in both directions.
Exactly.
You can have plagiarism that's not copyright infringement. You can have copyright infringement that isn't plagiarism. So there's
but I think it's worth mentioning with the credit thing. If you have the copyright on something, you can make the condition for you to give a license to a third party the requirement that third party acknowledge you, and the people do that. Like
you can make any condition.
No, exactly.
Right. Licenses,
but only with the copyright do you have that leverage to do it. So the question is, do we want to give people credit so badly that we want this burden of the copyright law to force them to give the credit? And that's really kind of like, for example, with an MIT license or most of these open source
Creative Commons license, often uses attribution as a condition for, in fact, most Creative Commons license have the attribution element, and that leads to some interesting discussions about whether or not you need that, and do you need copyright law?
Well, think about this. If there was no copyright law, there would be no requirement for a license. There would be no way to coerce any kind of
that's not
action except for social norms.
And that's what I mean about the law. That do we need a legal way to coerce this?
No, exactly.
Right.
And I think social norms are probably enough.
Because social norms, especially today, when everyone has a voice and we have social media and the ability to speak out, when someone does something that is generally perceived of as unfair or bad, then the public can speak out on it. And so when somebody copies somebody else without attribution, often that will come back to haunt them, not because of the law, but because of social pressure, right?
I think that's very much sort of it could be an American value. I'm not quite sure.
And it's worth pointing out too that other copyright laws in other countries treat this differently, right? So they have moral rights, especially in France, where attribution is actually a key part of the copyright law. And in fact, technically, you could argue that U.S. copyright law is supposed to have that because of the Berne Convention, and we're under international agreements, and so we do, but only for a very, very limited spectrum of creative works.
I can't remember, but isn't it true, like in the French copyright law, if you're an artist and you make a painting, you can prevent people from modifying the painting or something?
Yeah, that's part of the moral rights.
Yeah. You can kind of do that in the U.S. under 106A. So it's I like doing this copyright 101 thing, but every corner there's a monster lurking around it where you could dive really deep into.
Yeah. That's fine. We can do a surface dive.
But yeah, there are examples of people a sculpture is put on the wrong pedestal and the artist doesn't like it, and so even though they sold the sculpture, they've been able to block that display of it.
Yeah. This is in France, though.
Yeah, that's a French case. But there are the American equivalent law is new, and as far as I can tell, there's never been an application of it that just straight up makes sense. It's always been weird. Every single one's been weird. But the same sort of thing is possible under the law, which is strange.
What are we trying to protect in that case, in terms of the French, or what is that new?
I think for many people that's protecting a sense of fairness, a sense of a very broad and oversimplified distinction is that American law creates this right. It says, okay, in order to get progress, we'll invent a right where you can make exclusive. You have the exclusive right to make copies. And in Europe, they say, no, we recognize the right. Human beings, when they create something, have these rights to, for example, have their art displayed in the way they want it. And so French law recognizes that. And so you have this weirdness where these two systems, like, there are places where they overlap, but in a lot of ways, that distinction is a really important one.
It's a really big one. And so now some people react to that emotionally, and this is where some of the misconceptions come in and the things that we see. They react to sort of the French way of looking at it as sort of the natural right situation as being completely obvious, and that makes sense. And they often don't think of the consequences of it. So do you want to sort of dive into how that can be problematic?
Well, sure. So a thing that makes this weird as a natural right is that it lasts basically everywhere in the world after your death. Okay, that kind of makes sense that your kids, like I can follow you there. But it's strange to say that, like, after a certain fixed amount of time, you don't have this right anymore. There are not a lot of natural rights that apply that way.
Right.
Yeah, and if you don't have that, and there are some, there's some speculation that the way that the law, that there could be cases that say the moral right never goes away, then you have like can the children's of someone related to Shakespeare
or Marvin Gaye.
Well, that's a little more.
But yeah, or Shakespeare or Beethoven or whomever affect the way that can be performed.
Right. So could you? Not even that. Right. I mean, could you stop West Side Story? Right. Could the great grandchildren of Shakespeare say you can't do West Side Story?
So I think that's a point of kind of big confusion. Like, what's the difference between copying or being kind of influenced or inspired by? Like, I mean, West Side Story is not word for word, Shakespeare.
Well, that's
like,
a
how does
pretty
that
interesting
work?
question. There's the courts are supposed to do sort of an analysis of the structure of a narrative. I mean, obviously there can't be a bright line, right? Like, this is all a grayscale.
Well,
So if I take your entire story, let's say, I don't know, Harry Potter, and then do a search replace of every character name with some other character name I made, that's obviously a copy, even though they're separate characters. There's different character names, right?
Right.
However, if I take the same character names and put them in another story, is that a copyright violation? I think a lot of courts would say that is, if you use the same exact characters with the same.
But if you're inspired by this universe of wizards and children,
people control fan fiction. Like, you can't make another Star Wars novel and like sell it with the same characters. It's weird. So like, you can take but on the other hand, if you change both.
It's also a moving target in a way, because if you go back 200 years, copyright law in the U.S. didn't even cover translations into another language, where you can pretty effectively say that's a derivative, it's based on the first thing.
Right.
But none of the words are in common.
Right.
They've got a different word for everything over there. And so like, that used to not be covered, and now it is. And you still have that kind of change. I think a case that surprised a lot of people was someone wrote an unauthorized sequel to Catcher in the Rye.
Right.
Like, looking at Holden 6 years later, and that was blocked in a way that it seems like, well, he's not really copying anything.
Right.
He's inspired by. I mean, he was trying to
taking
sell
the
it.
canon that was created by.
Yeah, and it's not even that much canon. I mean,
Right.
not that should matter, but
Yeah.
it's like it's 180 pages. Like, sets up. He's a character basically who
Right.
Right, and
not
that
fun to
and so
hang out
that
with.
to some extent gets to this idea, which is another thing that I think confuses a lot of people, which is the idea expression dichotomy, as they call it, right? So people often think of copyright, and here's the sort of big misconception, is that it protects ideas, whereas in reality, it's only supposed to protect the specific expression.
Right.
But that line between idea and expression can be pretty blurry, as it is in the Catcher in the Rye case.
Yeah, but I think that, like, in that case, in the Catcher in the Rye case, that feels like that feels like a fine use. And I think where does that come into play in terms of, like, that case feels wrong, like, feels like a fine use. For me, like the Marvin Gaye case recently, that felt
The blurred lines.
The blurred lines it felt that they were fine, right? Like, how does, and I'm not sure like what the rest of society, like, I'm the least lawyery here, I think, but like, how does that feeling kind of catch up with the law? Or
Yeah, it seems like it ought to, and that's one of the important. That's going back to my favorite misconception. I think that's one of the reasons why why the flexibility of fair use is important, because you do have cases where judges go like, yeah, they copied the whole thing, but like everyone knows this way is fine, and you have like the very classic example from a technical sense is everything that search engines do,
Right.
because they have to copy everything in order to do what they do. And fair use analysis looks at that and goes, yeah, but they're obvious. It's so different, and this feels like everyone knows this is fine. But in other countries that don't have fair use, like Australia is deciding whether or not they should have fair use, and one of their reasons is that lawyers don't think it's legal to start a search engine in Australia, because they have a fixed list of exceptions. And
Right.
no exception is like copying every page on the internet or every book in a library in order to do
search it,
analysis on it. And
Well, it's interesting too, and this is something that I've seen. I agree with you that the flexibility is important, but I see the opposing argument, often from people who agree with us on a lot of other things, where they dislike some elements of the flexibility, and part of that is that you don't really know if something is fair use until it's been tried in court.
Right.
Going to the blurred lines thing, I think
Right.
a lot of the people who are looking at that goes, okay, this is actually a pretty black letter application of the law. There's no way that this is infringement, and we were $7.5 million wrong or something.
Thankfully, not personally.
Yeah.
$7.5 million wrong.
No, I bet a lot of money on this case, Mike.
But there is an argument, and there's a copyright lawyer that I know who pointed this out once, which he said he believes that with the 4 factors, you could make a somewhat compelling case, at least to certain judges, that any fair use case could go either way. And
Pretty much.
to some extent, that's a problem if you don't want things to be hung up by, fear of being sued or liability, right? Mm-hmm. And so I agree. I think the idea that we should have bright lines in terms of fair use is really dangerous, because you can't predict, where that's going to make sense. But at the same time, I do worry about the fact that everyone has to go through these lawsuits before we figure out if that particular use is, and then you have to wait for the next case to come along.
Well, I think for a lot of common law, I mean, that's just the way it is, right? Like it's very hard to make bright line rules about a messy world. So really, the only way to get out of the unpredictability about the way the law is going to fall out is to have a huge enumerated list of actual factual circumstances that you can rely on. There's nothing short of that. You can't get around that just because the world is messy. You can't enumerate.
And there are efforts like.
I think we're actually going to mention the American University thing,
that's exactly
right? So the fair use best practices for different fields, and that kind of makes it so that if you follow this, you can at least point to the fact
right.
that
you can have a defense that is effectively saying, like, I'm following these best practices, and
in the case of, like, at least in the case of documentary filmmakers who can rely on this guide, they get insurance. So
Exactly.
no one wants to go through a lawsuit except for EFF. We love lawsuits. Nobody wants to go through a lawsuit, but if you don't have to pay for it, that makes things a little better. And then the other thing is that I think, obviously, I'm a copyright nerd. I think that's obvious at this point. And I don't expect everyone to do this, but the case law is not, it shouldn't be, it should be more accessible, and it should be more, I think people should be more familiar with it. One thing that was a surprising and refreshing development is that the Copyright Office just put out a really impressive index of cases about fair use, where you can drill down by which circuit you're looking for and what the subject matter was. So photography cases in the Ninth Circuit, and you can look at that and you can say, well, not a lawyer, this is not legal advice, but that looks kind of like what we're doing here,
right. It's not a full collection, and it's only summaries. But
right, and I think that.
But it's a start, right?
Yeah.
It's at least a recognition, and there is this, and this is something that's gotten me in the past too, where it's like people think that fair use is like a small thing, right? As opposed to like this huge and really important thing that we sort of all rely on. And I think that's a big misconception as well in terms of, you know, how important it is. And for something that is so important, you would hope that more people would have a basic understanding of it.
Yeah. Well,
but they don't.
It's so complicated. I mean, you can't really, even lawyers can't get their heads around it, right? And until you enumerated the 4 elements, I couldn't remember all of them. I was like, what is the last one? I can't remember.
I wasn't sure if I was going to be able to do it on the spot. So
You see what I'm saying? It's hard to remember it, you know. So.
I mean, is there an ideal scenario? Is it like if Parker had his way with the world?
That's the next podcast.
Yeah,
That's next week.
Okay.
Because I think there is, and stay tuned for next week. No, there is, and it gets back to some of the differences between copyright and patent, I think. But it's especially in a world where copyright covers as much as it does for as long as it does,
Right.
and this non-verbatim thing, it's something that affects all of us every single day, and so it's fair use is so critically important to every one of us. And you know, I agree that this is something that we should know how it works.
Yeah, no, I agree. So I think that's a good sort of closing bit that leads into what we're going to be talking about next week, which is sort of how do we deal with those misconceptions and getting people to understand copyright better and why it's important to them to actually understand it. And so unless anyone has any final thoughts on this week's, we're going to close up here and people can say goodbye. You didn't all just walk out.
Adios.
All right. Thanks for listening. We'll be back next week. Thanks.
So let's go back to the start before 22. All music's in the public domain, so fuck you. It's never the amateurs that reckon it's damaging us. It's the major label saying it's fatal, like when Napster had to pack a rip by Metallica. The tables turn now, the labels churn out a new Jezebel internet televangelist, and she's fit with a manuscript that was actually written by Mr. Michael Masnick.